If you get into a petty argument with your neighbor over a property line, the state might eventually seize your home without ever charging you with a crime.
Right.
Or, depending on how things escalate, they might force you into a military-style boot camp, make you wear a literal scarlet letter in public, or lock you inside an invisible, high-tech electronic prison.
Yeah, it gets intense fast.
It really does. Today, we are exploring the bizarre, archaic, and heavily engineered systems society uses to manage human conflict. Consider this deep dive your master key to the hidden architecture of the law.
And we are looking at a really fascinating stack of sources today. It's a detailed glossary spanning dispute resolution and crisis and incident management.
Wow, quite the mouthful.
Yeah, but what emerges from it is basically a complete blueprint of how human beings handle disagreement. I mean,
Yeah.
It stands from hyper-local, village-level arguments where neighbors try to work things out over a table, all the way to the ultimate coercive power of state-run prisons.
Okay, let's unpack this. Because what is so striking about this material is how it blends traditional, highly formal, Western legal concepts with very specific community-based justice systems.
Exactly.
It is not just one giant monolith of judges and gavels. Before a conflict ever reaches a wood-paneled courtroom, communities actually have built-in defense mechanisms to keep people out of the formal legal system. We really need to start at the ground level.
We do. And at that local level, the emphasis is almost entirely on avoiding the state. The sources detail a system known as the Katarangeng Pambarangay.
Right, which operates at the barangay or neighborhood and village level.
Yeah, exactly. And the entire architecture here is designed for amicable settlement. It relies on the idea that, well, neighbors should deal with neighbors.
Which makes sense.
Right. And rather than just throwing angry people in a room to yell at each other, there's a very strict three-step hierarchy to cool down the friction.
So step one, the first line of defense is mediation. A Lupan chairperson, essentially the village leader, steps in to assist the disputing parties.
Yeah, and the goal isn't to declare a winner and a loser, right? It's to reach a consensus that satisfies everyone's needs.
Right, it's entirely cooperative.
Exactly.
But, people are stubborn, so when mediation inevitably stalls out, the system escalates to step two, which is conciliation.
Yeah, and conciliation involves a really fascinating shift in the psychological dynamic. A local group, known as the Pangkat, steps in to take over.
The Pangkat.
Right. But here's the critical mechanism. The Pangkat explicitly forgoes any power to decide the outcome. They cannot even recommend a solution.
Wait, really? They can't even suggest anything?
Nope. Their entire function is to just act as a mirror for the disputing parties, helping them isolate the core issues and explore their own options to reach a joint settlement.
Oh, wow. It operates almost exactly like a relationship counselor.
That's a great way to put it, actually.
Right. Because a counselor doesn't sit on a throne and declare, you are right and your spouse is wrong. They just facilitate the chat, forcing the couple to actually hear each other so they can figure it out themselves.
No, exactly. Yeah.
But let's say the neighbors still absolutely refuse to budge. That triggers step three, which is arbitration.
Right. And arbitration fundamentally alters the power dynamic.
Sure.
This is where a third party from outside the judicial system is chosen by the parties to hear the facts and actually decide their dispute.
So they do make a decision this time.
Yes. It culminates in an arbitration award, which is decided by either the Lupan chairperson or the Pangkat.
But that award only happens if the parties agree in writing beforehand to let these adjudicators resolve it, right?
Yes, that is a huge point. It has to be in writing.
So it's basically the equivalent of two siblings fighting over a toy and finally handing it to a parent and saying, fine, you make the final rule and we promise to live with it.
That voluntary handover is the crucial element of consent here. You are willfully giving up your right to determine your own outcome.
I have to push back on this, though. If these hyper-local, community-based systems are so beautifully structured with, mediation, conciliation, and arbitration, why do our formal courts remain so incredibly backlogged? What happens when that amicable settlement is agreed upon, but a week later someone realizes they were bullied, tricked, or intimidated into signing that piece of paper?
If we connect this to the bigger picture, we run into the legal mechanism of repudiation.
Repudiation.
Right. Repudiation is the act of rejecting the validity of an agreement. But, you cannot simply back out because you woke up with buyer's remorse.
You can't just change your mind.
Exactly. The threshold is high. Repudiation requires a vitiation of consent.
Vitiation of consent, meaning the agreement was secured through fraud, violence, or intimidation.
Yeah. So the yes you gave on paper wasn't a real yes because you were lied to. Or maybe your neighbor implicitly threatened you.
Right, that totally breaks the system.
It does. When consent is vitiated, the entire foundation of community justice collapses. I mean, community systems run on good faith.
Yeah.
So when fraud or violence destroys that good faith, informal resolution becomes impossible, and the dispute inevitably escalates beyond the neighborhood.
Which brings us to the imposing gates of the formal legal fortress.
Cue the dramatic music.
Seriously. Because when local arbitration gets repudiated, the dispute gets kicked up to the formal courts and the rules of engagement completely transform. You are no longer dealing with consent, you are dealing with state-imposed authority.
And that transition begins with jurisdiction. Jurisdiction is the absolute authority to hear and decide a case. It is granted by law, and it cannot be agreed upon by the parties.
So no more choosing your referee.
Exactly. The state dictates who has the power,
Right.
which is distinct from venue.
Venue being the actual physical location where the trial takes place.
Right, exactly.
So jurisdiction is the unseen power, and venue is the physical room. Got it. But once you step inside that physical room, you realize not everyone is allowed to play the game on their own.
No, they aren't.
The sources highlight a very specific, archaic-sounding category of people who cannot fully participate. The glossary calls them the incompetent.
Yeah, the terminology sounds like it was pulled from a 19th century novel,
It
honestly.
really does.
But the underlying legal framework is highly pragmatic. The category includes hospitalized lepers, prodigals, the deaf or dumb who are unable to communicate, or individuals of an unsound mind even during lucid intervals.
Hospitalized lepers and prodigals. It sounds wild to modern ears, but the logic underneath it is actually about protection, isn't it?
It is, yeah.
The framework recognizes that people suffering from specific diseases, severe age-related decline, or a weak mind cannot independently manage their property or defend themselves. They become incredibly easy prey for deceit and exploitation by the opposing party.
Right.
So the court mandates that a next of kin, like a relative or a responsible friend, must step in to represent them.
And it forces us to acknowledge how inherently vulnerable an individual is when facing the machinery of the formal legal system. The law recognizes its own complexity, and deliberately builds in safeguards for those who could easily be crushed by it.
And speaking of being crushed by the system, let's look at the immediate tools a judge can deploy before a trial even finishes. These are called provisional remedies.
Right, temporary judge orders.
Yeah. Instead of waiting years for a final verdict, a judge can issue these temporary orders to freeze the situation.
And these remedies represent the immediate coercive power of the state. Take the concept of attachment, for example.
Okay.
This is a legal order where a person's property is taken into court custody as security to satisfy a potential future judgment. The court literally seizes your assets while the trial is still happening.
Let's ground that in a real-world scenario so you can see exactly why this exists. Imagine you are suing a business partner who stole a $100,000 tractor from you.
Good example.
If you have to wait 2 years for a jury verdict, that former partner could easily sell the tractor, hide the cash in an offshore account, and declare bankruptcy. Attachment allows the judge to seize the tractor today, ensuring there is actually a prize to win when the trial finally ends.
Yeah, it prevents a victory on paper from becoming functionally meaningless in reality. Another tool is the preliminary injunction, which is an active command requiring a person to completely refrain from a particular act like, say, halting the demolition of a disputed building.
Right.
And then there is support pendente light, which forces one party to provide allowance, dwelling, clothing, or medical attendance to the other while the case is pending.
Here's where it gets really interesting, though. We are talking about the state seizing your stuff. The ultimate version of this is forfeiture.
Oh, yeah. Forfeiture is the big one.
The sources carefully separate this into criminal forfeiture and civil forfeiture. Now, criminal forfeiture makes total sense. It happens after a defendant is convicted of a crime with full due process.
Right.
But civil forfeiture laws empower the government to permanently take your property without ever charging you with a crime.
Wait, how does that mechanism survive constitutional scrutiny? Like, how does that bypass the Bill of Rights?
This raises an important question, and it is arguably one of the most heavily debated legal mechanisms in existence.
I can imagine. The distinction relies on a profound legal fiction. In a criminal case, the human defendant is afforded full due process. But in civil forfeiture, The lawsuit is actually filed against the property itself.
Wait, what? The government is literally suing a pile of cash or a car or a house?
Yes. The legal theory is that the property itself is guilty of facilitating a criminal enterprise. Because the property is the defendant and inanimate objects do not have constitutional rights, the state can bypass the standard protections afforded to a human citizen.
That is wild.
It's a staggering amount of authority wielded by the state in civil matters.
Okay, so that handles how the state controls property. But what happens when the formal court system establishes guilt and actually has to decide what to do with a human offender? This plunges us into the fundamental philosophy of punishment.
Yeah, the big why.
Right, why do we punish people and what is the actual end goal?
Well, the sources outline two fundamentally opposed frameworks here. The first is retributive justice. This paradigm views a crime primarily as a violation against the state itself. It is rooted deeply in retribution, which is defined as the oldest form of punishment. It's that ancient concept of an eye for an eye.
You broke the state's rules, so the state is going to break you a little bit to balance the scales?
Exactly. The focus is squarely on penalizing the violation of the law. But standing in direct opposition to that is restorative justice.
Right.
This framework views a crime not as an offense against a faceless state, but as a direct harm inflicted on the victim and the surrounding community. It relies on restoration, calling for the offender to make direct amends to the people they actually hurt.
So it is the difference between balancing the scales of pain versus actively trying to heal the harm.
Beautifully said, yeah.
And underneath both of these philosophies are the practical goals. You have deterrence, which is the attempt to prevent future crime by making the consequences too terrifying to risk.
Right.
And then rehabilitation, which tries to fundamentally alter a criminal's behavior through education, vocational training, or mental health counseling.
But where this material takes a truly unexpected turn is in its exploration of restitution.
Yes. When you hear the word restitution, you naturally think of a financial transaction. If you break my window, your restitution is paying me $500 to fix it.
Sure.
But the sources explicitly link restitution to community service and scarlet letter punishments.
Mm-hmm.
We are talking about punishing people through public shaming.
It is a deeply sociological approach to justice. The material notes that society frequently utilizes this form of shaming because it provides and I'm quoting here, cheap and morally satisfying alternative to traditional punishment.
It is cheap for the taxpayers, and the public gets a morally satisfying show watching someone hold a humiliating sign on a street corner.
Yeah.
But then the material immediately undercuts its own premise. It states that scarlet letter shaming is highly unlikely to succeed in changing the behavior of repeat offenders, simply because those individuals are already accustomed to breaking society's rules.
Right.
So if the data shows it fails, is public shaming really just an ancient form of revenge, masquerading as a modern, progressive solution?
That tension reveals a dark truth about justice systems everywhere. Societies often implement punishments because they fulfill a primal emotional need for the public.
They feel morally satisfying.
Right. Not because they are functionally effective at altering the offender's trajectory. Public shaming requires the offender to actually care about the community's opinion.
Which they often don't.
Exactly. When they prove they do not care, the state abandons restitution and falls back on its most blunt, reliable instrument, incapacitation.
Which simply means removing a person from society. We stop trying to fix them, we stop trying to shame them, and we just put them in a box where we no longer have to deal with them.
Yeah, when cheap and merely satisfying methods fail to alter chronic behavior, the state prioritizes containment over correction.
So let's look at how that actually plays out in the physical world. How do these high-minded philosophies of retribution and restoration translate into the actual physical restrictions placed on a human being's life?
Well, the state utilizes a ladder of sanctions, starting at the lowest rung.
The lightest sanctions begin with fines, which are typically levied against first-time offenders for minor infractions like traffic violations.
Right. And moving up the ladder, we see community service, which involves unpaid work performed for the public benefit.
But it's not strictly voluntary here.
No, crucially, this is often a court-ordered service, making it compulsory. It acts as a direct substitution for incarceration.
And as we move up into behavioral supervision, we hit probation. Now, probation is actually the most frequently used criminal sanction, but it is not a free pass. The conditions are aggressively strict.
Very strict.
A probationer must obey all laws, submit to unexpected drug tests, regularly report to an officer, and refrain from traveling outside a specific geographic area or even associating with specific people.
And if an offender requires even more intense oversight without being fully incarcerated, the state deploys intensive supervision probation, or ISP.
ISP, yeah.
This allows the offender to remain in the community, but under incredibly severe daily restrictions.
And sometimes the state decides that even strict probation isn't enough of a shock to the system. For young, first-time offenders, usually in their teens or 20s, the court might mandate a boot camp.
Boot camps.
Yeah, this requires 3 to 6 months of rigorous military-style training. The entire mechanism here is designed to break down the offender's defiance through extreme physical and psychological discipline and then rebuild them with respect for authority.
It's intense.
It's a highly concentrated dose of retributive deterrence.
It really is an attempt to force rehabilitation through controlled trauma. But for those who don't fit the boot camp profile or who require tighter geographical control, the state utilizes house arrest and electronic monitoring. The offender is confined to their home for the majority of the day, enforced by a transmitter strapped to their wrist or ankle that constantly beams their location to a monitoring unit.
So what does this all mean? When you step back and look at probation, ISP, and electronic monitoring, it looks remarkably like an invisible high-tech prison.
It does.
If the state dictates who you can speak to, where you can travel, what fluids can be in your body, and tracks your physical coordinates 204/7 with an ankle monitor, is that actually freedom? Or is the state simply outsourcing the physical walls of the prison to your own neighborhood and making you pay the electric bill?
What's fascinating here is how modern technology fundamentally blurs the ancient lines of incarceration. You're watching the state turn the offender's own home, their private sanctuary, into a localized extension of the penal apparatus.
Wow, yeah.
The walls are no longer made of stone. They're made of data and surveillance.
But sometimes the state still demands those physical walls. The sources actually trace the etymology of the word imprisonment.
Oh, right, the Latin root.
Yeah, it originates from the Latin word prehender, which literally translates to seize. It is the absolute state of being physically captured and confined in an institutional setting.
And there is a vital functional distinction between the types of institutions used for this physical seizure. Specifically, jails versus prisons.
Right, they aren't the same thing. Jails are essentially short-term holding tanks. They are operated at the county level by local sheriffs.
Yeah.
The populations inside jails are largely unconvicted defendants who are just waiting for their trial because they cannot afford bail. You also have convicted misdemeanants serving brief sentences or felons doing short stints for a probation violation.
Prisons, conversely, are long-term penal facilities operated by state or federal governments.
The big ones?
Exactly. They are designed for serious convicted felons. This represents the ultimate, most severe physical manifestation of retributive justice and incapacitation. The state has fully seized the individual.
But because we live in a society that constantly attempts to balance this immense state power against individual liberty, there is one ultimate constitutional check on physical imprisonment.
And that would be habeas corpus.
Exactly.
It is arguably the most vital legal mechanism in a free society. Habeas corpus is a judicial proceeding explicitly designed to release a person who is being illegally deprived of their liberty.
It is the ultimate prove-it mechanism. The state has seized you, they have exercised their power of prehender, and a writ of habeas corpus forces the state to drag you in front of a neutral judge and legally justify exactly why you are in a cage.
It acts as the definitive safety valve against tyrannical or bureaucratic incapacitation. Without the constant threat of habeas corpus, the state's power to physically seize its citizens would be absolute and unchallengeable.
So to bring this all together for you listening, we have mapped out quite the journal today in this deep dive.
We really have.
We started at the hyper-local neighborhood level, watching a barangay pangkat utilize conciliation to forge an amicable settlement, relying entirely on mutual trust. We examined how repudiation shatters that trust, forcing disputes into formal courts governed by strict jurisdiction, where the state wields provisional remedies to freeze assets.
Right.
We navigated the turbulent philosophy of punishment, weighing the ancient eye for an eye against community healing, and exposing the functional failures of scarlet letter shaming. And finally, we tracked the physical escalation of state control from community service and military boot camps to the invisible digital walls of house arrest, culminating in state-run prisons and the critical safety valve of habeas corpus.
It is a vast, heavily engineered, and often contradictory system that mirrors our own societal struggles with vengeance, healing, and order. But as we reflect on all these elaborate mechanisms of control, there is one final concept from the sources worth considering:
Oh, what's that?
the statute of limitations. This is a law that entirely bars the institution of a legal case after a certain prescribed period of time has expired.
A literal expiration date on the law.
Exactly. Consider the underlying tension. If restorative justice tells us that a crime is a deeply personal trauma inflicted on a human victim, and retributive justice tells us that a crime is a profound, intolerable violation against the state itself,
Right.
then why does the state intentionally build an expiration date into the pursuit of justice? Is a statute of limitations a mechanism of supreme mercy for the accused, allowing them to eventually live without the terror of the state looming over them? Or is it a quiet, pragmatic admission by society that over time, the absolute truth simply becomes too hard to find, and we would rather close the book than risk destroying an innocent life?
That is exactly the kind of underlying question that proves legal jargon isn't just a moat to keep you out. It is the source code for our fundamental morality. And you now have the keys to decode it. Thank you for joining us on this deep dive, and keep questioning the invisible systems that shape our daily reality. Catch you next time.